I get to talk apparently about the boring part, as Andrew said. So, good evening, everyone, and welcome. We're going to hit a little bit on conservatorship and guardianship tonight. We're going to talk a little about some alternatives to it. But what is conservatorship and guardianship? Because it's often confused. I get a lot of questions these days. Should I conserve somebody? Do I need a guardianship? When do they apply? The first thing to know is that a guardianship and a conservatorship are a legal requirement created by a court. They cannot be done unless a court orders either one of them. When we're dealing with these cases, there's some preliminary issues that comes up all the time. The first is that someone is presumed to be competent. If you're over 18, we presume you to have competency to make decisions, to handle legal decision making documents and everything else. So the burden of proof is actually on the petitioner to show that the individual isn't competent. Guardianship and conservatorship are not about extending parenthood. It's not an extension of the rights as a parent. In fact, it doesn't allow you to always overrule somebody. And that becomes something we're going to talk about a little bit later, but it's a very big thing with guardianship and conservatorship. You have a duty under either one of them and the duty of loyalty to make sure you follow the person's wishes. So if they don't want to do something, you can't always force it. And the idea for guardianship and conservatorship under the statute is that they're only available for as the least restrictive means. Basically, everything else has to fail before the court's going to want to order them. Now, what isn't incompetency? Physical disability is not someone automatically incompetent. Old age doesn't mean someone's incompetent because someone's eccentric, whether they're younger or older. The issuance of poor judgment does not make you incompetent. And just because of an IQ score is not an automatic incompetency. Even though in Connecticut, a guardianship for a disabled child is only available if their IQ score is below 70, it's not an automatic. You can have a case where somebody, and I actually had this case, somebody had an IQ below 70, yet they were so competent that the judge was not going to give them or give the parent, in this case, the guardianship. We were able to fight it off because she could make good decisions and she was able to live on her own. So IQ alone is not enough. There has to be more.
So, and again, this is no 18-year-old makes great decisions. This is not saying that they're going to make bad decisions. It's saying that they can't make decisions. Right. And again, we're going to go over some alternatives and some of the reasons why and what we ask. It is needed for some.
Right. It's not that you can't or should never do it. It's just that they should be utilized in the right places, because when they are needed, they're absolutely needed. But there's a lot of misuse of these things, and it's getting attention right now, but that's gone on before. So what is incompetency? The legal standard is basically the inability to receive or evaluate and communicate decisions. A way to look at that is, can you understand the nature and consequences of what you're being asked or the decision that you're making? So do I understand that if I were to walk outside right now and walk into the middle of the street, that I run the risk of being hit by a car? Yes. Now, what if I really want to get across the street and I do it anyway? Am I incompetent? No, it may not have been a good decision, but I'm still competent. I'm still legally capable of making that decision.
Now, what about Comcast customer service? I think they're pretty incompetent most of the time.
I mean, I would think all cable companies fall under that statute.
I mean, risk of financial harm, overcharging us. I don't think they communicate or evaluate decisions.
I think we just have them on fraud right there.
Oh, okay.
So there has to be that risk of financial harm. And the risk isn't dealing with Comcast or any cable company in this case. The risk is the person going to be ripped off, and not just fraud, because people can be a victim of fraud and still be competent, but are they able to actually understand how to pay their bills? Do they know to pay their electric bill? Do they know that there even is an electric bill? That's what we mean by risk of financial harm, not just someone else taking advantage of them or taking their money, but can they even do any of those activities? And we have to show that the need for an incompetency standard cannot be met otherwise. So powers of attorney, can the person do a power of attorney? Oftentimes I would start there before I would jump to anything else if the person's capable.
So we're going to get into that later, some of the less restrictive alternatives. We want to start with what people do know. Also, just something that Steve mentioned, because we deleted some of the slides, I just want to go over is during this presentation, we're using guardianship and conservatorship pretty interchangeably. Guardianship is only if you have an IQ below 70. In Connecticut, it's different in every state. Conservatorship accomplishes roughly the same goal if the IQ is above 70. And actually, many times you need guardianship and conservatorship if it's under 70. So we're trying to not do the whole presentation on the differences between conservatorship and guardianship because they're, really kind of interchangeable.
The terms are used interchangeably in a lot of states. Connecticut's a little different, and with the meaning behind them is important, but the theme of tonight is more just understanding the general nature of what these things mean.
And there are other
and
options.
and that there are other options. And Andrew's correct. Like, we have had cases where there's a guardianship and a conservatorship because they can be used together depending on situations. But so what's it like going through guardianship? First there's issues that you have to go to court, like I said before, and it's not just going to court. So the way the process works is in Connecticut is the person who's going to be conserved or have a guardian appointed by statute, they're referred to as the ward. That's how it's written in Connecticut. It's been written that way for a while. And they get their own attorney. And then the parent gets their own attorney. And you end up in those cases where everyone has a fight over what's going to happen because the attorney's job, who is going to represent that person, is to fight. If they don't want the guardianship or the conservatorship and they're not willing to consent, it's that attorney's job to do what that person wants. So we've had these cases, and perfect example is a case that came in that we rejected. Was someone who wanted to have a child conserved because they didn't think that child was making good decisions. The child was, playing video games too often. The child didn't want to get a job right away. The child was having a ton of these issues at home, and they were just not happy as parents. So the only
They
thing they thought of is, let's conserve her.
And the other part there is they were hoping that the conservatorship would allow them to live more independently. We also think, again, if
Not allow the individual to live independently, allow the parent to live independently.
Or was it both?
I think it was the parents.
So
that one. The
but
parent
yes,
thought that it would give them more freedom because they would be able to kick the child out of the house as part of it. That was a lot of that too. But at the end of the day, the individual was competent. The fact that she chose not to have a job or didn't treat with the doctor that the parents wanted to doesn't mean the person's incompetent. And had this gone to court, the court-appointed attorney would have fought and would have won, because not agreeing to go to a medical treatment that you don't like, refusing to take pills, refusing to get a job doesn't make you incompetent. And it's not grounds for the parent to do it. And in Connecticut, there is a DDS evaluation. Here's where the big differences lie between guardianship and conservatorship. So a guardian is just appointed to do all of these things. But a conservator is usually a conservator of the person or a conservator of the estate. The estate part is financial, and it basically pays bills. Where you'll see them combined with the guardianship is a guardian will need a conservator if the individual who's being conserved has more than $10,000. You can't be a guardian of someone who has more than 10. So you can be a guardian for medical only, but not for financial purposes. So if a child has lower income or lower assets, that's going to be something. But either one can apply for benefits, deal with vocational issues. This is where the stuff gets fun, whether it's a guardian or a conservatorship. The standard for making decisions for someone is really important for anyone who's thinking about being a guardian. You have a fiduciary duty. That means you have to put the individual's wishes and goals over your own, and you have to do what's called the best interest standard. Now, best interest standard means you're supposed to make the decision that's in the best interest of the individual, but you have to also consider what they want. So let's say I'm appointed to be Andrew's conservator. And I happen to know that Andrew really, really does not want a monster truck. He probably does, actually. I can't go out and buy it for him because it's not in his best interest. Yeah, that's not a good use of the funds. Now, if he goes to me and says, you know what, I really want that truck, maybe I have to reconsider because it goes in with his goals. So while it has to be his best interest, I also have to give some leeway to what he wants. I can't just overrule him on every decision. I'm not his dad. I'm not his boss. I'm supposed to be someone who honors his and respects his wishes and asks his opinion. When we do things, we have to do it with diligence and good faith. So we can't just delay a decision because we're hoping the person will change their mind. Um, that's a terrible method. We've seen that before. People, just hold off doing something for so long because if I don't agree to buy this car right now, they'll change their mind in a week. That's not reasonably prudent, and it's not with diligence and good faith. So the obligation when you're appointed to be someone's guardian or conservator is to represent them, not your wishes. So there's some potential issues that aren't addressed in guardianship paperwork or not addressed by just the statutes. And that's the dignity of risk. What issues are we going to face with the individual? Are we going to have issues with sexuality or identifying it or anything that could occur? And balancing the health concerns, dealing with their friendships, their preferences and decision making. You don't get to overrule something. Like, I can't tell Andrew he can't be someone's friend tomorrow. If I'm his conservator, that's not my role. In fact, I can't even block that person from visiting him. I'm supposed to allow it to continue. I'm supposed to actually help facilitate those things. So you have to make sure you identify these things before you even file. And one big one that happens a lot, especially in cases where it's tight, and I mean tight, like, we're not really sure we need a guardianship, but we're not sure we can do the power of attorney, and the decision's made to go guardianship, is you run the risk of long-term relationship changes. And if you take someone's rights away and you have them declared incompetent, it doesn't necessarily equal them loving you the same or liking you the same way. So it's one of those things, we always want to explore the psychosocial part of this. Is you have to be ready and willing to say, hey, I'm going to be, create an enemy here. Yeah. And we put caution tape on Andrew because that was fun. And because we bought caution tape at Home Depot one day.
Yes. So, and again, a couple other things just to, chime in is there are certain rights that are taken away. A common thing that we suggest and recommend is lots of individuals with disabilities maybe start their own business, have a hot dog cart, sell some arts and crafts, maybe not even so much for the money, but for something to do and keep them busy.
Right.
Well, if you're under conservatorship or guardianship, you can't own a business, right? Because you don't have the capability, again, according to the court, to make those decisions. So, it's very important to also think about the future and employment and, of the individual, and to think about that nobody lives completely independently. So it took 10 years, but apparently for like the past couple months, I've been actually putting my laundry in the hamper. My wife is thrilled. Took over 10 years, right? But I need support, right? Everyone needs support. Nobody lives completely on their own. We all have people that we call. We all have, friends who are nurses or teachers or doctors or lawyers or financial advisors. I mean, so we all having there's nothing that replaces a good network support system as well, which is
right. Right. No one is truly 100% independent. Like, none of us are. Andrew and I probably less than some, but no one is truly independent. It's why we have teams that we work with and we have those friends. So when we're looking at exploring, determination of guardianship or conservatorship, we want to look at the least restrictive means because there's this balancing act of I have the right of self-determination, but someone wants to protect me. And as parents, protection doesn't just end because the child turns 18. Protection doesn't end ever. I actually was in a meeting today with a client, and mom's in her 80s, her daughter's in her 50s, and mom's trying to explain to her why she shouldn't be shopping so much on Amazon because she won't have any money in the bank. No, daughter's in her 50s, clearly knows what she's doing, and she's made her way in the world. But mom's still going to have that view of, I want to protect my child. I need to impart some wisdom. And that's the difference between the self-determination and protectionism issues. That's an important thing. We want that type of protection, right? We want people to share those things. But we don't want to have the issue of a guardianship where we're trying to overrule everything of the other person and we're trying to take over for them if they just need some support and some decision making. Because the things that happen in a lot of guardianships and why so many fail, and why they turn into messes, and why you see some on the news at night now is because there's things guardians don't have authority to do. They don't have the authority to limit visitors and phone calls, religious expressions, actually sexuality expressions now. They can't just file grievances on, it's a limited right to file a grievance if they dislike what somebody does on behalf of the individual, if the person wants to. You can't tell them not to get a haircut. I've actually had a case where someone had an issue with clothing and wanted to say they couldn't have a certain piece of clothing. No, if they want the clothing, whether they have a guardian or a conservator, you get them the clothing because your job is to do what they want and to help them and not just put your own views first. That's the fiduciary duty. So, Andrew, you want to?
Yeah. So supported decision making, old concept or new law, or not even necessarily new law. So to simplify things a bit, I'm going to say that ideally that nobody attending this today you shouldn't think about and try to go in depth to guardianship or conservatorship and figure out which one's right for you. You should take a step back and think about, well, where do you want to go? What do you want to accomplish? And then we look at what's the best way to get there. For example, if an individual is turning 18 and they're still in the school system, transition, and is till 22. If you call the school without a document on file, well, they're 18. The parent can't speak to the school. Well, if your goal is to be able to speak to the school and get information, releases can be signed. The same goes for doctors. You can help make financial decisions with what's called a limited power of attorney, which assumes that the individual is able to make decisions, but if they have this on file, then other people can make the decisions with or for that person if they don't want to. At the end of the day, when it comes to supported decision making or anything that is not guardianship or conservatorship, it's the individual themselves who has the final say. And I think that's what a lot of people, want. The parent, the guardian, is able to get information. They're able to help make decisions, but they're able to make decisions with the individual. And so, again, this is me and Steve. That axe is dangerously close to my neck. We went to Harbor Freight, not where we bought the caution tape. And, we're allowed to make bad choices. The pipe wrench was only $10. So I got it over here somewhere. I don't know how much the axe was, but,
$5.
$5. I consider that a good decision. It was a good deal. But, when people are able to make their own decisions, they feel more empowered. It can be hard to, again, even getting a license. You can't, now this isn't as applicable in Connecticut. Not as many people are concerned with getting a permit, a gun permit. You're not allowed to do that for even 20 years after one day of conservatorship. You're not allowed to have any firearms. And it can be very, demeaning to need to, ask, especially if we're trying to promote some independence. And so we just want to encourage people to know to ask the question, what are you trying to do? Are we trying to help get information from doctors and school systems and the banks and help teach the individual and make decisions with the individual? Or are we saying that the individual is completely incapable of making any decisions? And the answer I generally find is, they're not. And if a parent and anyone listening to this has already made the guardianship or conservatorship option, we don't want to, shame anyone. It's there for a reason. It's very important. There are absolutely people who can't make their own decisions. And also, there is not enough awareness about supported decision making. So we do run into many people who did a conservatorship and didn't realize that this was an option, and they wish they had known first.
Right.
So we're not saying that it's the only option. We're not saying that you should never do guardianship or conservatorship. What we're trying to say is it should be the first option considered. We have a great flow chart, which Ashley will also send out later, but that's the last page on our slide.
The
So
idea is that this,
Can
it's
you
not
guys
to say,
can you guys share the slides with me also? Is that possible? And then I can I'll put
Of
both of those
course.
out in an email to everyone who participated. That'd be perfect. Thank you.
Yeah.
it's not about like, yes, we're going to do guardianship or no tonight. It's more about the idea of being informed and making an informed decision. I'm a goal-based planner. When I look at a plan, whether for any type, whether it's estate planning, special needs planning, at the end of the day, it's what are we trying to accomplish that guides how we go. And that's what we really want to accomplish tonight. Is just start thinking about that. What am I trying to do? Because I've had conversations with parents on numerous occasions where it's more been, I just don't trust the person because they're 18 and they might make a mistake. Guess what? I'm in my 30s. I still make mistakes. It happens every single day. It's what happens. It's how we learn. If we, I want someone who's going to make some mistakes. When I hire a new employee, I tell them to make mistakes because if they do and they learn from them, that's going to be a good employee. If they're don't even try, well, then they're never going to grow. So we want people to learn. You want people who are going to try things. Well, we want the same thing with the kids. It's how they grow. So when we're looking at this, what's the goal? It was we are, and sometimes it's figuring out our own personal values and our own personal goals and how we're viewing this rather than just how we're viewing the child, because sometimes you have to take that step back, and look at it independently.
So again, important to ask what areas do we need support with? There's a very long document that I'm sure nobody on this meeting will ever read. But no, in all seriousness, you should read it. That the Supported Decision Making Coalition has put out. It's very long. And, what I caution is I find, especially around the time that parents are making these decisions, that there's so many other decisions and the thought of this is so overwhelming. So that's why I really say, what areas of support does somebody need help with? And, is there a least restrictive way to do that? And, you have to remember too that the courts are unable to give an opinion. So if you go to the probate court and you say, I'd like guardianship or conservatorship, Steve, are they allowed to recommend any other alternatives?
And usually that seems to be what everyone, are they allowed to? Maybe, but most don't. I think people should. I think, there always are alternatives, and we should consider I mean, if you read the statute, it actually says you should always consider least restrictive first. If we're going for a conservatorship or a guardianship, it's required to be the least restrictive means have all failed. So by law, we're actually supposed to do that. So Does everyone recommend it? No. Should they? Yeah, and they won't. Um, and I think that's a shame, unfortunately. But looking at it from the least restrictive, you don't. Who wants to be the most restrictive? Like, you don't want to lose all of your own rights. And the reality is, when we're doing a guardianship or conservatorship, we're taking away someone's rights. That's what it is. That's why they get a court-appointed attorney, just like in a criminal case, because it's viewed as taking away rights.
So this is a flow chart we made. I think it's probably the best thing on this presentation, mostly because I made it and not Steve. But no, I think it's a really good, simple way, for how to evaluate if you should explore a form of supported decision making. Now, one thing that I can imagine happening is if you start Googling supported decision making or you're looking into it, you'll notice that there's no law in Connecticut necessarily on supported decision making yet. That doesn't mean you can't do it. So all of the legal tools, authorizing a release to speak to the school, authorizing a release to, for healthcare, authorizing a release for financial, all of these things exist and they're able to be put together. However, it's not in the law as a streamlined package along the lines of conservatorship and guardianship. So although the process for those can take a bit longer, in some ways it can seem simpler. Here's a very short form for conservatorship or guardianship with the probate court, but where do I go and what do I fill out for supported decision making? So what I don't want is for people to wait on the state of Connecticut to do something productive. You don't need to wait for Connecticut if they ever do have legislation that, let's say streamline supported decision making. That won't affect any decisions made today. So we do think that would be a good thing, as it would increase awareness, which is why we're here today. And we think that's one of the biggest areas, where we meet resistance, is most people are just not aware that this is an option. They want to get information from their child's doctors and the school systems, and, they're told guardianship or conservatorship.
Right.
So,
And I think a lot of the flaw in that, and they're told these things, is oftentimes most of the parents I've met with recently who were on the fence about whether they needed to do it were told they should do it because they wanted to overrule a child's decision. But again, that's not what guardianship or conservatorship are about. They're not about overruling. They're about supporting the individual and using their best interest based on what the person's own views are. So you can't just do something 100% that they would be against. That's a violation. That would get you removed.
Another thing to think about too is if you're helping someone build a support system around them, and you're helping them, build, whether again, informal or slightly formal, right? I mean, we all probably have a friend who's a nurse or works at a hospital where we get that little rash. I know I bother my mother-in-law, right? Hey, what's this? Right? Instead of WebMD, I'm not sure which is better, but like that's an informal supported decision making, right? You may know a family member in finance or somebody who's a teacher or somebody. So building that like just informal network of, people we can rely on to, help make decisions with us is really important, because as a parent, assuming when you pass away, the fact that in theory could overrule someone, and you may say, I never overrule my child's wishes. Well, what about the next person? What about the next conservator? What about the next guardian? Who is that going to be? And, how will, and what can you do to ensure that that person won't overrule them? And I think really the only way to ensure that is to, consider supported decision making first. And I just want to end with, if it is okay to do guardianship or conservatorship, it is absolutely needed. We see cases all the time where it's needed. But it's much easier to go more restrictive than to go less restrictive. So just like school, IEP, you need to, least restrictive environment, or just kind of continuing that process. And we just want the least restrictive environment to support an individual in their decisions.
And I think in the same line of what we want, supported decision making is law in a few states. So there is hope here. But even the idea of conservatorship and guardianship in some ways was originally established around the idea of supported decision making, because you didn't necessarily get every single power. The powers were based on the case, and the judge determined the power that the person got. Now, with guardianship in Connecticut, we've kind of gone, with a limited guardianship, the judge determines the power. With a plenary guardianship, we just give you everything by statute and say, here, you get this whole kit and caboodle. And if there turns out we didn't really need everything, well, you got it all anyway. But the idea behind it was originally to support the individual and their wishes. And that's really what the shift has been in bringing it back. There was a time where the state kind of got away from that and actually got sued. There was a really big case that hit Connecticut a number of years ago that changed the statutes as well as how the rules were being applied because of that view, with the whole idea of we have to support people in the way they want to be. So with that, I think we can open it up to some questions, if there are any.
How do I do
Perfect.
this?
So if anybody has specific questions that they, want to bring up to ask Stephen and Andrew, I mentioned earlier, if you missed it, that you can drop it into the chat, which is on the bottom of your screen. You can unmute and ask your question. And if it's something that's more specific or private that you'd like to ask separate, by all means, you can email me and I can pass that along to Andrew and Stephen. If you want, maybe you could share a little bit more. So if they're going to start this process, what would you say is the first step for them?
I think the first step is, it's always going to be evaluating the goal. Again, to me, that's it. If we're talking, are we going guardianship or conservatorship, or can we go with something less restrictive? If it's medical decision making and the person is capable of making decisions on their own but needs some support, then I start looking at an advanced directive. Just naming someone to make decisions when we're not capable. It's just like I need one now. I have one. If I got sick and I can't make my own decision, I name someone to make it for me. Well, that's a good starting point. And to me, the two most important documents in any estate plan, and it doesn't matter if someone's younger or older, are the power of attorney and the advance directive. It's not the will. Everyone always thinks it's the will. The will doesn't matter until you're dead. What matters to me is more what happens to my stuff while I'm alive. Making sure my bills get paid, making sure I get treated with dignity and respect, making sure my medical wishes are followed. That's going to be the biggest issue for me. That's going to be my biggest goal. So to me, any plan should start with those. If we can't do those, if the person isn't competent enough to do that, then we have to look at going to the guardianship or conservatorship option. But it has to be that the person is not competent enough to do the other items. If I can get by with the other two documents, I would start there first. And like Andrew said, if we start there and we find out 5 years from now or 3 years or even 3 months, hey, it really didn't work, like it just wasn't enough, then we can always go stricter. But it's very difficult when someone's already been conserved or had a guardian appointed to reverse it. It's possible and it does happen. I don't want anyone to think it can't happen, but there are stigmas, there are certain restrictions that apply for a very long time afterwards. Andrew talked about one with the firearms, but if you get conserved for one day, you can't buy a firearm for 20 years afterwards. You get conserved, your rights are going to be impacted for a very long time in a number of other areas. So we really want to look at those things and making sure that the person is still competent and capable.
Perfect. We had Mary Coons asked, regarding a driver's license, what would prohibit someone from being able to get a license?
Can you say the question one more time?
Sure. Regarding a driver's license, what would prohibit someone from being able to get a license? So
Well, if you're declared, a guardianship may not necessarily prevent it, but a conservatorship, you're basically getting a declaration of incompetency. So you're saying this person is incompetent to make decisions for themselves and their own safety, and we're going to put them behind the wheel of a car. So I think it would be very difficult to go and get a license there. I don't know that it would prohibit it forever or that it's impossible, but I think it would make it a lot harder to go in and say this person should have a license. I've never had a person who's been conserved then go and drive a car.
But you have had individuals who someone does have guardianship over them that have been able to do that process and get their license.
With limited guardianship, I've had people who have then gotten a license. But limited is the key, because if it's a plenary guardianship, I think, again, that would be a finding of incapacity and incompetency to be able to do pretty much every activity of daily living on your own.
And there's also, when you think about it, again, you think about how many decisions somebody makes when they have to get in a car.
Right.
So, from an insurance company point of view with car insurance as well, that the person who's the guardian or the conservator, would be completely responsible if there was an accident. Think of it like your 16-year-old child got in an accident. So I'm going to go out on a limb and say if the individual is capable of driving, they should probably not have conservatorship. That's not to say that it doesn't happen and maybe there aren't good, it should probably be reevaluated. If the individual is capable of driving, they're putting their lives and others in their hands every single
I'd say that's
day.
a fair assessment. If the person's going to need a conservatorship, right, and even with a plenary guardianship, same thing. Limited, it may be an option, but he's right. From a practical standpoint, I don't know any insurance carrier that would want that case.
Definitely. So somebody followed up and said, if we chose supported decision making, what are the other legal documents we should set up? So that was going to be my next question too, is, okay, you go to the probate courts, you fill out your documents. I know that there's an evaluation that DDS does, but leading up to that, and I think that this is where sometimes people get caught and don't have this information of what are the different routes that they can take and what are the different options that maybe are the least restrictive. So in supported decision making, what would you tell somebody that's exploring that to do?
Until the child is 18, other than your own planning, you can't do anything, because they have to be over 18 to execute documents. So in your own planning, that's where trusts or special needs trust may come into play. And trusts aren't just used because someone has a special needs or has a disability. They can be used for a ton of other reasons. So they can still be relevant even if someone isn't disabled. But trust would be a good starting point. Having your own plan set up with powers of attorney and documents, and making sure that there are people appointed as guardians if the child is a minor. All of those are good things that any parent should do no matter what. Once the child is 18 or getting close to 18, that's when we start looking at other things. That's when there's if they're within 6 months of 18, we start looking at competency and capacity. If they're able at that point to start making good decisions, then at 18, they can sign a power of attorney and an advance directive. If they're not able to do those things, then we have to lean towards guardianship. But there's nothing that can be set up under a legal document other than a power of attorney or an advance directive in Connecticut. You can write, I've had clients write letters. I've had clients, state out specifics of things they would like. They're not legally enforceable. They're not bad things to have either. I highly recommend, just writing those things out, but they're not legally enforceable.
Does anybody else have any other questions to follow up, or any, I know that a couple of different things were brought up, even about trust and special needs trust. And, you know, Andrew is a financial planner and might be able to share a little bit about how to, you know, start those and get those set up. So if anybody has any questions on any of that. As
Andrew's
always.
answer on setting up a trust is usually call Steve. So,
So call Steve.
but yeah, I mean, trusts are probably the most powerful tool we can set up in our estate plan. I mean, I have a trust, and because the trust allows me to avoid probate, it holds my assets. It allows someone to manage my funds if I get sick and pay my bills. So trusts are just really, really flexible, right? And what they can do as a tool. And then when I pass away, it allows me to distribute money to beneficiaries in a number of different ways. You can have outright distribution where the person just gets the money. You can have a distribution that's held back. We have good behavior trust for people. If we have drug, alcohol addiction, there can be money held in trust for people who just spend every dime, like we call it spendthrift. And we have trust. We have a trust called the Speed Bumps Trust, which comes from parents who want to run over their daughter's boyfriends with cars. And I've had more than one client who's wanted to do that. But really, what their concern is that their child is going to get divorced and the idiot that they marry will end up with some of the money. So we can put the money in trust to kind of avoid some of the conflicts or some of the issues or anything else and hold it for their benefit. So it's still their money, but it's held for them. So trusts are a really good tool that people can use and can utilize in their planning. And it gives us probably the greatest amount of flexibility. And then for supplemental or special needs, there's generally two versions you're going to hear about: first party and third party. Basically, you want third party for everything because first party pays back to the state.
Perfect.
So
Thanks
we always want third.
Good to know. What is the difference between limited power of attorney and normal?
The terms of the document.
One's limited and one's not. I know that.
Essentially, that's technically the right answer, actually, but it's the terms. The terms of the document are different. So for a limited power of attorney might just specify certain things. Like I could do a limited power of attorney to authorize Andrew to go buy a car for me tomorrow. It's limited to the scope of that one task. Or I can broaden it up. So the terms of the document control whether it's limited or standard.
And what would a standard power of attorney encompass?
Depending on how it's drafted, I can draft a power of attorney that gives him power to basically do any financial transaction that I could do for myself. So he could buy his own real estate. He could make gifts to my beneficiaries. He can do whatever. If he could just go in my account and do whatever he wants. Or I can limit him to certain powers. I only want him to be able to pay gifts, or only want him to be able to communicate with certain people, or only be able to pay these bills, or only transfer money to certain people. I can basically pick and choose what I want. So the limitations are essentially established by what you do in the document.
And that would only be if and when you weren't able to make those decisions to make those payments, send the gifts and that, or they would be able to do that on your behalf while you're still functioning and doing your day-to-day stuff.
You just let me give my favorite legal answer. It depends.
It depends. Jinx, you're it.
That's right. Damn it. Because the answer is it depends on how it's drafted.
Okay.
So I can do it any of those ways. I can make it so it only works when I'm incapacitated, or I can make it work tomorrow. It's up to me and how it's drafted when the time it's done. That's where the kind of the art of these things, or the planning side of it, comes in. Is we have to start figuring out what we're going to need. And in some cases, we're planning with what I call a broken crystal ball, because really with it, you're making guesses as to what we may or may not need. So sometimes limited powers of attorney just get redrafted very quickly because they're only for a certain task, and we might realize we need more, and sometimes they're all we need.
Sure, that makes a lot of sense. So, the power of attorney, which you had said, those two things, the power of attorney and the advance directive are really the first steps in determining whether or not, you could do the supported decision-making route versus going into the more restrictive guardianship conservator route, is to look at those pieces and to go back to the question about what other legal documents should they set up if they're looking at supported decision-making. Again, you're going to say that those are the two things that they should start with, and that's where it's going to give them the flexibility to support.
Everything kind of starts there, because again, it goes back to more than that. It goes back to the idea of, just because we disagree with someone's decisions doesn't mean we need to conserve them or put a guardian on them. So if we're going to, honor their wishes and respect them, but they still want our assistance, they still want that guidance or someone to be able to help pay those bills, and they can meet the competency rules. So they're not incapacitated, they're not incompetent. They can sign a document and understand enough about it that they're legally competent. Then we're going to start with those two things, because if you're legally able to sign a power of attorney and you're legally able to sign an advance directive, then why are we going for a more restrictive routine when there's clearly something that's less restrictive that can work here?
Yeah, that makes a lot of sense. Anybody else have any questions? Again, if there's something more specific, feel free to email me, and I can certainly pass that along to Stephen and Andrew. They're super knowledgeable and super helpful, and have good senses of humor.
Thank you.
If not, I thank all of you for joining us tonight. Stephen and Andrew, thank you for taking the time to put together the presentation and share that information. If it's all right with you, I'll share your contact information with the group, along with the materials that, the flow chart that you had mentioned, as well as I think it was a 42-page document that has a lot of information within it. And I will share this recording as soon as I figure out how to, with everyone that joined tonight. That way, if you want to go back and look up anything or listen to any of the parts, you can do that. But again, thank you all for joining, and I hope to see you at future Transition Tuesday workshops. And everyone, have a great night.
Thank you. Have a great evening, everyone.
All right.
Thank you.
Oh, somebody did just ask, with the power of attorney, do I still need to sign a HIPAA and a FERPA?
Yes.
That was
Keep it simple.
And Monica is still on, so perfect. All right, great. All right, thank you guys so much. I really appreciate it. And I don't think this will be the last of our meeting and talking. I hope to work with you guys again in the future. So
we look forward to it.
All right. Well, have a good night, guys. Thank you so much.
Thank you.